that Judge Feist did not forfeit bail?
On the 19 case?
Yes.
Okay.
So we would just have to do bail on the 21 CF case.
Well, I mean, we address bail on both cases.
You ready?
Yep. Call a case.
State of Wisconsin versus Rodriguez Crawford, 19 CF 5663 and 21 CF 3874. Appearances, please.
Chad Wozniak appears on behalf of the state of Wisconsin.
Mr. Crawford appears with attorney David Conley. Good morning, Your Honor.
All right. Good morning. So both of these cases are before the court on a return of warrant. And so in both of the cases, the court will vacate the bench warrants as Mr. Crawford has been brought into custody, but we need to address bail on both of the cases. So let's talk about the 19 CF case first. That case is going to remain before branch 4. And so, Mr. Wozniak, what is the state's position on bond?
Well, I guess, did you want to go through defense to see if there's a basis for it, or do you just want me to go?
Pardon me?
Did you want to go through the defense to see what the rationale is, or do you just want me to go?
You can explain your rationale, please.
Okay. So my records indicate that the warrant was issued on November 18th of 2021. In the 19 case, he previously had $5,000 on this case, what my notes reflect. I think the bail has to be somewhere in the range of $15,000 additional bail to whatever was previous there. So if the court wants to keep that bail, that original $5,000, I would ask for 20. If the court's going to revoke that $5,000 or forfeit it, then I would ask for the $15,000 in cash. It's a serious offense. He's shown you that he's not going to come back to court. I don't have a basis for how he ended up coming back. At this stage, nothing's reflected. But it's pretty alarming to me that he's alleged to have an armed robbery, and then he picks up a new case where he has a firearm. And it's not just any kind of old random revolver. It's a pretty expensive gun with a laser sight. So I find that aggravated. I think $10,000 in that 21 case then is appropriate. So in total, I'd ask for the court to add $25,000 in bond. I think given the length of time he was out for, that's appropriate.
All right. We're just talking on the 19 case. You're asking for 15,000 new money.
Yes, sir.
Okay. All right. And for Mr. Conley.
Yeah, thank you, Judge. So according to CCAP, it looks like there was a bench warrant that was issued on 10/28/21. And then there was some notes in there. It said defense counsel contacted the court and state via email to schedule a return on warrant hearing. So Mr. Crawford indicated to me that he, at the time, did not have a working phone. That hearing looked like to be by Zoom. He later had contacted, this is coming from him, that he had contacted his attorney in the matter. And then that attorney then set that new date in hopes of clearing that bench warrant. Between that time, he indicated to me that he suffered an injury. He says that he was actually shot and that his jaw was broken and was in the hospital. I don't have any records right now to give to the court to verify that, but that's why he says that he missed that 11/18/2021 date. I can tell the court that Mr. Crawford, I printed off his last PSA that I believe was from looks like when the new case, the 2021 case was issued, that PSA indicated that he should be on level 4 supervision at the time, that he should be released on a recognizance bond. And I think the main reason for that was because Mr. Crawford has absolutely no criminal history. He doesn't have any misdemeanors convictions. He doesn't have any felony convictions whatsoever. And he doesn't have any out-of-state record indicated either. So I understand that he has these pending cases, but as far as a criminal history is concerned, he has absolutely no criminal history. I understand that Judge Feist didn't vacate or didn't take away that $500 or $5,000 bond that he had. I would ask the court to leave that. I think that, as far as, imposing more cash bail, I think $15,000 on the 19 CF case is certainly very high. I don't think that that's appropriate. The fact of the matter is that Mr. Crawford has absolutely no money at this point that he could potentially post. So if Your Honor does impose a additional cash bail, I would ask it to be somewhere maybe like $500, not, $15,000. Otherwise, I would ask the court to keep that bail. And I recommend that mainly because Mr. Crawford doesn't have any sort of criminal history, and that obviously right now he's still presumed innocent for these two cases. So with that being said, Mr. Crawford does have substantial ties to our community. He indicates that he has family here. One of the reasons why he was having so much trouble at the time was he indicated that he was homeless. He told me now that he can stay with his mom. His mom lives at 425 North 27th Street here in Milwaukee. He says he does have a supportive family otherwise. So because he does have substantial ties to the community, I'm asking the court to leave that $5,000 cash bail as is. Otherwise, to impose a reasonable amount, I don't think $15,000 is reasonable. Thank you.
All right, thank you very much. I would agree with you that $15,000 would be unreasonable if he had no criminal record and he had made all his court appearances. But the situation drastically changed. It really becomes irrelevant to look at the PSA that was done in September of 2021 because since then he's bench warranted on 2 cases for a significant amount of time. I really am unable to give any weight whatsoever to the excuse of failure to have a phone. Every single human being over the age of 8 years old has a cell phone in America at this point. I'm saying that with a bit of hyperbole, but it's probably almost 99% true. And so if you don't have a phone yourself, you can always borrow one from someone who might be standing right next to you, or even borrow a stranger's phone for a moment to call your attorney, call the court, and let them know what's going on. And with no communication whatsoever, it shows just a lack of desire or motivation to communicate with the court or his prior counsel. In terms of the assertion that he had a medical issue, I really can't make any determination on that, and so I'm not going to consider it. I would have to see all of the medical records, find out when he was in, what the nature of the problem was, and see that. And that can certainly be done over time. But again, unless he was in a comatose state for a lengthy period of time, you can always call and advise an attorney or the court of his status. And almost every, or I believe every hospital room has a phone in it, landline phone, and you can just make a phone call, a local phone call. So I'm not giving any weight to that. He was out on a bench warrant for months and months. And that's very concerning, especially given the serious nature of the offense. There's no indication that he came into custody voluntarily when he did. And so he presumably would continue to be out on a bench warrant, but for being picked up by the police on for some reason. So given all of that, I believe that substantial cash bail is appropriate. What I am going to do is forfeit the $5,000 that he had posted, order it held for recompense and costs. And so that is forfeited, but ordered held for recompense. And then I am going to set bond at $15,000 cash. It's a turnover to Justice Point. It's a level 5 supervision with no dangerous weapons, absolute sobriety, so no use of any illegal drugs, drug testing as well. And if there had been a no contact order with the alleged victim, the court would order that that no contact order reinstated as well. And so that's the order of the court on the 2019 case. Now I'll hear bond argument on the 2021 case. Mr. Wozniak.
Yes, Your Honor. Really, it's maybe moot, but I do think that 10,000 is appropriate on that 2021 case. Really for the reasons I previously stated. In that case, he bench warranted again right around that same time. He was out for a lengthy period of time. I think the facts are aggravated that the way he bail jumped in this case with the firearm. I think that's very aggravated. I think that's cause for concern. That was reflected in his original bail, which was $2,500, which is high for a felony bail jumping. But obviously that was not enough to get him to appear. So a significant increase up to $10,000. I think is appropriate.
All right, Mr. Conley.
Thank you, Judge. Well, the court already ordered $15,000 in the other case. As I expressed before, Mr. Crawford doesn't have any money to post that amount of bail, is what he indicated to me. From my previous arguments, again, he does have substantial ties to the community. And because of that, I would ask the court to not order such a high cash bail at $10,000 there. Something more reasonable, under $5,000, I think would be more appropriate. Thank you.
Okay. Yeah, this 2021 case is a less serious allegation. There's less exposure in terms of potential prison time if he were to be convicted. And so the court takes that into account. And so given the nature of the 2021 case, the court believes that a lower amount of cash bail is appropriate. Clearly, the $2,500 was insufficient because he posted that and forfeited it by his failing to appear. So the court is going to increase it to $4,500, so $2,000 more. So cash bail is $4,500 on the 21 CF case. That would again be level 5 supervision, turnover to Justice Point, and same conditions, no absolute sobriety, no dangerous weapons. All right, that case is a case that my clerk and I have determined was improperly tabbed to branch 4. It should be tabbed to Judge Child's court. And so we're going to retab it to Judge Child's court. However, it needs to be processed through preliminary hearing court. And so, Madam Clerk, do you have a court date for that?
Yes, next court date will be for a preliminary hearing on April 28th at 8:30 a.m. in prelim.
Okay, that is the orders. And
Judge, are you reinstating bail on the 21 CF case?
no, that bail is forfeited and gone. I can't reinstate it.
Okay,
It was forfeited in September of 2021. The notice of forfeiture was sent out, it appears. And so it was forfeited. So I couldn't get that back even if I wanted to.
Thank you.
And then, do we set a status date for the 19 CF case yet?
We have to set a status of council date because Mr.
Okay.
Crawford will need appointment council.
Right. Okay. How about the week of May 23rd? Mr. Wozniak?
Anytime.
We'll set it for May 27th at 8:30 a.m.
Thank you.
I agree.
Okay, May 27th, 8:30. Okay, very good. That's scheduling from here. Anything further for the record, Mr. Conley?
No, thank you, Judge.
Okay, that's the end of the hearing. Thank you very much, everyone.
Have a good weekend, everybody.
Yep, you too. Thank you. Bye-bye.
Is Mr. Binder still in the waiting room?
Yes, he is.
And we're still on you
You
streaming
know who
live.
this held KD is?
I do not. It might be